right, well, we're going to go ahead and get started today. We're so pleased that anyone can join us today. And of course, this will be recorded so that it can be played back live. All right, so today I'm so happy to have Rusty join us today from Pat's Law Firm. And so we're going to be talking about healthcare directives, a combined medical and legal approach. And Rusty's going to really help us to understand from a legal perspective about health directives and advanced care planning and things of that nature. So we're very lucky to have Rusty. But before we get too far into this, I always want to make sure that we do a disclaimer, both for myself and also for Rusty. This presentation is for our information and our educational purposes only. While I'm a licensed physician and Rusty is a lawyer, we are not acting in the capacity of those professions for you here today. And we don't want you to construe any of this as medical or legal advice, and there's no diagnosis or treatment that's being established. No client-physician relationship, no patient relationship is being established during this presentation as well. All right, getting on with that, a little bit about Wellspring. We always start with this. Wellspring, we believe in the power of compassion, effective communication, and empowering education to transform lives. It's the reason why we do these presentations. We want you as a consumer to be able to have access to reliable and credible information, because there's so much information on the internet nowadays. We want to make sure that it is well vetted. And so that's why we bring experts on like Rusty today to help talk to us about these types of important topics. So you can always keep in touch with us. Reach out to our medical assistant, William, at telephone number 816-708-1661. And if you're, of course, a facility, don't hesitate to reach out to Brandy, our Chief Operating Officer. All right. Now, we've got Pat's Law Firm here. Rusty, would you tell us a little bit about yourself?
Well, probably that right there says most of it. I was an accountant and decided I didn't want to do that. So I did what most people who are confused do, and I went to law school. And so when I got out of law school, I was a tax attorney and continued with the confusion. Started with a law firm. Fortunate, very nice firm in Blue Springs doing estate planning. I started working with older people, and older people hang around older people. And so eventually it got to the point to where the only people I was representing were seniors. And so before the term elder law was even coined, I was an elder law attorney. And so for now over 30 years, that's pretty much all I've done. It's really asset protection, estate planning, general legal work for issues that are common to people who are older. So, we don't do divorces, we don't do traffic tickets, we don't do bankruptcy. Those aren't common. Death, disability, and dementia are quite common. So we deal with that pretty much exclusively.
Well, that's wonderful. Thank you so much, Rusty. I appreciate that. So, of course, I want all of our listeners and our watchers to be able to reach out to Pat's for any other questions that they may have, to seek a consult, to get some further specific advice. And so I have here listed their website at www.patslawfirm.com. And they have two phone numbers, one for their Kansas residents, 913-380-1701, and then Missouri, 816-542-3466. All right, well, let's go ahead and jump on in here to healthcare directives, our combined medical and legal approach. So, Rusty, you've prepared some of these slides for us, and I'm very appreciative of that for us. So you have here this legal requirement for a healthcare directive in living wills. So tell us a little bit more about this and what exactly a living will is.
Well, I put it under an umbrella just kind of to a lot of people come in and they try to use words. They don't really understand how this all works. But under advanced directives, for example, or healthcare directives specifically, we're talking about several things. And so we're going to talk about, in this case, one of them is a living will, which is also referred to as an advanced directive. The way I remember that is I'm going to give somebody direction in advance. What direction am I giving them? I'm giving them the direction, what to do when I can't do it myself, when I can't give that direction myself. And that is usually, like it says here, life-sustaining treatment. So I'll talk about it typically. If somebody's in a persistent vegetative state, that's kind of a phrase I use a lot. Or I also talk about, instead of life prolonging, I'll often talk about death prolonging terminology, meaning you are dying. Somebody is dying. They're in the dying process, so to speak. We don't know if it's going to be an hour, a day, or a week, but it is there. And we're just not going to prolong that process. And so a lot of people, I just had somebody the other day, the son, 56 years old, had a stroke, and they were talking about a DNR, which we'll talk about DNRs. And I said, well, it doesn't really apply here because, he's not in that condition. We'll talk about it a little bit later. But a living will is basically saying, and I've had to do this because I act as a agent for people, where I've had to pull the plug, so to speak. And it's basically in advance telling people that, hey, if I have a terminal illness and I'm somewhere in the dying process, in advance, I want to tell you that I do what I do or don't want to do regarding my life and this illness and treating it. And just so
That's
people,
awesome.
just so people know, Alzheimer's and dementia or even coma, those are not necessarily, death prolonging or, terminal illnesses. At some point they get there, I understand. But just because you have that diagnosis doesn't mean, suddenly you're going to withhold medical treatment.
Exactly. I think sometimes it's so handy. So as a hospital practicing physician as well too, it's very we are always appreciative of people that have advanced directives, because that helps to put I look at it as a framework for me in terms of what they want, because they've probably already articulated that they don't want a feeding tube or they don't want a tracheostomy. And that's a lot of the time what we're dealing with is someone comes in and they're really, really sick and they've got sepsis and they're in the intensive care unit and maybe they're hooked up to a ventilator and their family members are overwhelmed with the current situation of what's going on. And so it's very difficult for family members to try and process the current situation and to think prognostically moving forward about what their family member would want. And so what's great is when someone's taken the time to already stipulate, I don't want a tracheostomy, right? So that we're going to continue to treat them and we're going to do everything we can up until that point of maybe 12, 13, 14 days where they've been on that ventilator. And now we get to the point where we have to decide, this is not going to improve potentially ever, but certainly we need to make the decision about whether we do a tracheostomy to continue to prolong their life or whether we remove and compassionately extubate that patient. And having that advanced directive, I think, is very handy for those types of purposes. So definitely like that. All right, let's jump into our next one. You have a couple of criteria that has to go into that. Yeah.
Well, sorry. One of the things you said something there at the very end that I learned early on in my career when I first acted. These living wills are not really, on my end of things, they are not really for the patient. It's for the family of the patient.
Mm-hmm.
Usually the people that they're listening to help make these decisions are the last ones who are going to withhold anything to prolong the dying process. Usually the doctor, the hospital, the friends, the family members are all saying, oh, let him go. And so as being the person that has had to do this before, it's given great comfort to know that these conversations have been had and that they have spelled it out and given me permission to do what I feel like has to be done.
Absolutely. No, I know, Rusty, we have a couple of criteria here that they have to be in writing, signed, and witnessed, right? So that's a caveat. You can't just kind of scribble this out on a piece of paper on your kitchen counter and take that as your advanced directive. You need to have this done with some assistance and help and have it signed the right way, right?
Yeah. And you technically you can write it out on a piece of paper, but to be honest with you, people aren't going to feel comfortable with that, and they may not readily accept it. And like you mentioned earlier, you're in a very stressful time because the hospital and the doctors and the nurses, they just want to help.
Mm-hmm.
And so we don't want them to be uncomfortable. So it is nice if it's done in a acceptable, professional, more presentable way. Yeah, but the law does, these are the only requirements of the law, though.
Okay. All right. All right. So now we have this declaration. Help walk us through this. I know there's some criteria here. So what do we mean by this?
Well, there's nothing that's magical, so to speak, about any declaration. There's not a lot of things that have to be there, but there is the statute in Missouri. Kansas, they have something similar where if you want to, you can just pull up this statute and it gives you a form to use for a living will. And that's what I've done there. I've just given the statute and what it looks like.
Wonderful, wonderful. Okay, so this is something that someone could use in order to kind of give them a framework or starting point of what they wanted to talk about.
Yeah, and this is one thing, because you're going to talk about some other stuff. This isn't like the cure-all, but for this particular issue, I think as long as we give the hospital and family things that they can rely on, that are legitimate, that and I think this would go a long way.
Oh, certainly. No, it does. And I definitely think that these advanced directives give the healthcare team the foundational framework. Now, like you said, that unfortunately there's a lot of gray area here, right? Like someone may come in and they may have a massive stroke and not be able to really communicate on their own. They're not reliably able to swallow. They've not passed a swallow study. They can't get weaned from the ventilator, but they're not in a persistent vegetative state, or they're not brain dead. So they're in that gray area, so to speak, between being fully capable of being able to make their decisions and not being able to make their decisions. And so this helps people to give that framework of what their overarching goals might be. If I see an advanced directive that says, I want intubation, I want a feeding tube, I want dialysis, that tells me that that's a person that very much is focused on trying to prolong their life at all costs, at all measures, right? Whereas if I have a patient who, on the other hand, says, I don't want life prolonging measures, like I don't want a tracheostomy, I don't want a feeding tube, I don't want to be on dialysis, right? That helps to point me in another direction of what their thought processes were thinking, so that I can then talk to the family members about what life might look like in the current situation that they're at, to then get some more clarity in those grayer situations. So it helps to put that framework in place. All right, let's go ahead. This is another example then of a healthcare treatment directive of where you would sign some, put your name in there and things of that nature, right, Rusty?
Yes, Nancy Cruzan's attorney, her family's attorney back in I think it was the late 70s. In the 80s, he started the Center for Practical Bioethics. And there's some other stuff too. It's a great website, but this is a common form. On the other side of it is a healthcare power of attorney. On this side of it, it's the advanced directive. I don't think it's superb, but to be honest with you, because I'm sure you've seen it, the hospitals and doctors' offices hand it out like candy. So, even without reading it, people recognize it immediately. And so I would not suggest redoing it if this is what's used.
Perfect. All right, so we've got a couple of legal requirements for our healthcare directives. And so we're going to start with our DNR and our out-of-hospital DNRs. And so Rusty, why don't you start us off by talking to us about DNRs and out-of-hospital DNRs? That's what the OH-DNR stands for.
Yeah, right. Well, and actually, you'd probably be the far better person to do the regular DNR. I don't think there's as many requirements for that. I don't run into that much, to be honest with you, because if they're in the hospital, I'm not sure what all the requirements are there, because of course the hospital is, I'm not going to question the experts on that. where I come in is really when somebody is in a nursing home or at their home. A lot of people want to die at home. And so that's the out of hospital DNR. And that's where you actually find far more of the law that I work with. Would you, I guess, would you agree that the DNRs that you see in the hospitals, that's something that you guys know intimately well?
Yeah, so in the hospital, what will happen is I'll always address someone's code status because I want to make sure that I'm respecting of their wishes. So even if this is someone that I've taken care of before, either at a nursing facility or they're a primary patient of mine, always ask them, in the event, the unlikely event that something should happen where your heart or your lungs stop beating or you stop breathing, what would your wishes be in that situation? And they then will respond whether or not they want compression, CPR. We talk through that process. And then I do a documentation piece. And that is sufficient in the hospital-based setting for our documentation pieces. And then I put an order into the computer that says that the patient is a do not resuscitate. And then that's put in big bold letters, and the patient wears a purple band around their wrist to indicate that they are in fact a do not resuscitate. And I agree with you, Rusty. I run into the out of hospital DNRs a lot in our nursing home situations because our patients in the nursing home is not legally able to enact an out of hospital DNR until that purple form is signed. And we have a picture of it here a little bit. And so it's extremely important that we get those signed in a timely manner. And so, for instance, a lot of the facilities that I work with, this is something where I'll often come in and meet with the patient on their first or second day in the facility. And we'll talk about this because I feel very strongly that we need to respect the patient's wishes and know what their wishes are. And so sometimes they'll be like, I want to think about that, or I want to talk about it with my family member, because sometimes not every doctor has this conversation with patients. And because they don't, sometimes it's the first time that they're hearing it. And so they get a little bit nervous. They're like, why is Dr. Haas mentioning this to me? Does he know something that I don't? And so it's a lot of reassurance. And so sometimes they think about it and they're like, I really don't want to have my chest compressed and I don't want to have my ribs broken. And because I don't think that I'm going to have a meaningful chance of recovery afterwards, right? Because if someone's, in all honesty, 85 years old that has 6 or 7 different chronic medical conditions, the likelihood of them recovering from a massive event like a cardiac arrest out of the hospital where they've stopped breathing and their heart hasn't started beating is very, very low. American Heart Association documentation says that it's probably around less than 12% of people are actually able to recover, and even fewer are able to actually leave the hospital and return to their previous state of health. So you have to really kind of take that into consideration in regards to what you want. And most of the time, if we're doing chest compressions correctly, we're probably going to break some ribs, especially in someone that's a little bit more frail. So I think that the out-of-hospital DNR and the DNR forms are extremely important. And so I want to go ahead and we got a few other things in here. So a lot of the times we don't talk about DNRs unless we think that they're very important, right? So I'm 43, I'm healthy, I don't have any major medical conditions. So someone like myself, I'm not going to elect to be someone that has a DNR, right? Now I've had patients that have been in their 40s, 50s, 60s and said, I don't want to undergo the resuscitative process. I've seen my mother go through it. I just don't want to do it. In which case we can certainly respect those types of decisions. But I think it's more important in the situation that you have listed here, right? Where it's that highly likely to not have a reasonable return to meaningful function. Is that what I'm understanding from this, Rusty?
Well, there has to be a physician that signs the DNR. And I'm specifically talking about a out-of-hospital DNR. So it's not just like where you can declare, I don't want resuscitation. There needs to be an incurable or irreversible condition, which in the opinion of the physician is such that death will occur, likely within a short time, 6 months or less, and regardless of the application of the medical procedures. So yeah, it's like you said, it's not just something that people can, a 43-year-old or even a 61-year-old can just sit there and say, hey, I want a DNR. And then, if I choke on a piece of candy or something, people can't resuscitate me. Well, I wouldn't have an out-of-hospital DNR because no doctor would sign the necessary purple form that needs to be presented.
I see what you're saying. So that would be that conversation with that doctor, because I think that if a patient, so when I think of that in terms of the incurable diagnosis, I think of it as, typically speaking, usually an out-of-hospital cardiac arrest, right? Where they've stopped breathing or their heart stops beating. So in that situation, they would in fact then have a incurable situation or death. And so if someone was to tell me, as a physician, if they came to my office and they said, "Doctor, I saw my family member do this. I don't want this to happen to me," I would potentially sign an out-hospital DNR in that situation, where we had this extensive conversation talking specifically about what a code status is, what those types of factors are, to try and respect their wishes to not have their chest compressed or not to ever be intubated. Because I've had a lot of patients that have been very vocal about those types of things. So it all depends on the circumstances, I think, Rusty.
Could you answer this then? So I'm 61, and as far as I know, quite healthy. So if I had that issue, I don't have an incurable or irreversible condition right now. But if I had a sudden cardiac arrest, my thought on that was that in order to have, if I have a sudden cardiac arrest, the problem is I won't have a DNR in place in advance because I don't have that incurable or irreversible condition. But you're telling me, and you're educating me on this, and sure enough, if I don't ask the question, somebody will come in tomorrow and ask this of me. So you're saying that I, as a healthy 61-year-old, I could walk around with an out-of-hospital DNR just in case I have a cardiac arrest?
Yes. If you came to me and you said, "Dr. Haas, I don't ever want to be intubated. I don't ever want to have chest compressions. I want to walk around with a life alert bracelet that says in big bold letters, 'Do not resuscitate.'" If you said that, I would respect your wishes in regards to that, knowing that, yes, you don't have a condition right now, but based upon your age, your comorbidities, it's not unreasonable. In all honesty, it's not unreasonable for anybody in this country to think that they couldn't have a massive MI. I mean, that's one of the most likely causes of these types of situations that we have. And so if someone's very much focused on not undergoing those measures, I would potentially sign that form. But I think it's going to be a focused conversation with that physician. And again, that's why I think it's so important to go back to even our little disclaimer that we had earlier, is because these are very individualized decisions, and we need to have these conversations with those people so that we can make the best decisions possible for everybody. So.
Oh, yeah. That's very helpful. Yeah. There's a lot of ethical things we could go down the path of there. We don't need to, right?
Absolutely. And that's why it gets it can get very sticky and very gray. And so it's really important to make sure that we're talking about that in a frank and open conversation with your physician and your attorneys, as a matter of fact. So, all right. So we have some requirements here, and we are running short on time because this has been such an awesome discussion. So I want to make sure we get through a good portion of this. So we have to complete the out-of-hospital DNR form. It's going to be effective when not being treated in the hospital, and it's going to be signed and dated by the patient's physician as well. So I do those every day, and this is what that form looks like. So it has you have here, like you can see my arrow here. This is where the patient's information goes, and then you have here the physician's information goes down here. And then this area right here, I think, is very important, because one thing that we haven't talked about, Rusty, is the right to revoke this order. So if something changes in your mind or in the way in which you're feeling about this, or you read more information or you think more about it, you're like, no, maybe I don't want that. Maybe I want the opportunity to be resuscitated. You can always revoke these types of measures.
Can't you also revoke it at the moment? Verbally?
Well, you can. The problem, Rusty, is that most of the time, in my experience, when I'm coding someone, they don't have the ability to respond.
Oh, yeah.
Right. So they are completely obtunded. They can't respond. They can't tell me what's going on. And a lot of the times, even if they're someone that's becoming maybe they're in the hospital or they're bradycardic or something's happening, they're not mentally cognizant and aware to be able to make a decision. So I wouldn't necessarily trust someone's judgment in that moment if they weren't able to be fully alert and awake. So it gets difficult, but yes, you could, or who could do it is your durable power of attorney, which I don't know if we have time to get through all of those types of things, but we're gonna have to have another one of these talks, Rusty, because you're just a wealth of information and we're having some awesome fun here with these discussions. So, all right, we are going to have time to talk about a durable power of attorney. So why don't you tell us, because I know that the term agent is very important here, and I want to let you have the opportunity to talk about that.
Well, that's the third item. The first one was the advanced directive, then you have the DNRs, and then you have the durable power of attorney for healthcare. And I referenced that earlier with the Center for Practical Bioethics. But basically, it's a legal document where a person appoints an agent to make medical decisions should the patient, we'll call them, your person, become incapacitated, which, basically just unable to express. And that incapacitated is the ability to take in information or the ability to process it or the ability to disseminate information in such a manner that there's a problem. They need to be able to do that. So this is the person that stands in their place to make those decisions.
Rusty, sometimes I have patients that get apprehensive about appointing a durable power of attorney because they're like, well, I'm capable of making my own decisions and I don't want my daughter making my decisions for me, or I don't want my son making decisions for me. And I always try and reassure them that this is a worst case scenario. This is that backup person so that when you are unable to make those decisions for yourself, and sometimes we don't know when you're not going to be able to make those decisions for yourself. And as a physician who does have to unfortunately deem people incompetent from time to time, it's one of those situations that I take extremely seriously. And we do multiple different types of tests. We are looking at different factors. We're talking with speech therapists. We're talking with our psychiatrists. We're getting a comprehensive approach before we ever go down the pathway of saying that someone doesn't have the ability to make their own decisions. So what do you tell patients when they're struggling with that concept?
Well, I always say the decisions are difficult, but the options are few, because if a person has not in advance put a power of attorney in place, then there's only one other option, and that is a guardianship through the probate court. And that's expensive. It takes a tremendous amount of time, and it's burdensome on a lot of people. So those are the only two alternatives. And people, in fact, today, somebody said, well, when do I need to do the power of attorney? And I said, well, before you become incapacitated.
Absolutely.
I always talk people into it and say, what I mean by talking them into it is I say you only have two options, and that is you've either done this or your loved one's going to have to spend a lot of money and go to court and take, usually depending on the court, it's going to be probably 5 to 12 weeks to get things in place. So they usually pretty quickly say, well, I want the power of attorney.
I'm sure. No, absolutely. Now we are under a minute here, actually under 30 seconds. So we're going to have to definitely have another one of these calls. But so we want to make sure that we update this every 5 to 6 years or upon every major event. And then we're going to certainly have another one of these, and we'll schedule that out for people. Rusty, it's just been an absolute pleasure meeting with you and talking with you today. And thank you and the entire team at Pat's Law Firm for helping us put this together. And I look forward to having another call with you soon.
Thank you, Dr. Haas.
Thank you.